This is case number 24-3984 FH. Appearances from counsel, please.
Nate Carnes on behalf of the people.
Thank you, Your Honor. Patrick Cherry on behalf of Jeff Stark, who's present.
Do you have any amendments, corrections, or objections to make?
No, Your Honor.
How about you on that file alone?
Yes, Your Honor.
Yeah, go ahead, sir.
Beginning with page 1 of CFJ 145.
Yep.
Under education, it should reflect the same as the other PSI, which is a vocational certificate.
Oh, okay, thank you.
Alcohol use from 1997 through the arrest date.
All right. Anything else in that particular report?
Your Honor, I think we'll have to deal with it in both reports. I'm turning to page 2 for the time of credit.
Okay.
We need to add a box for April 8th of 2025 through May 12th of 2025. April 8th is when the court revoked the bond in this matter. May 12th is the date that the contempt sentence began.
Yeah.
Occupation, janitorial.
Okay.
Monthly income, $800 a month. Religion, either Christian or Baptist. I didn't know what selections they have. Baptist would be particular, Christian would be general.
All right, copy. Mr. Stapleton, did you catch that? Religion, just put down Christian. Let's be unified here together. All right, let's put down Christian. Religion, Christian,
Okay.
employment, janitorial, income, $800 a month.
Okay. The last one,
I'm sorry,
drug
was it
abuse
$800 a month or 800 bi-monthly?
per month.
Per month, thank you. All right, yes, Mr. Chair.
And then drug abuse, yes.
And Mr. Carnes, when I asked you the question about corrections, I only talked about the 2024 report. Do you have anything to add to the 2025 report?
Your Honor, I do think it would be appropriate to score OV-19 at 10 points.
Mr. Cherry.
Thank you, Your Honor. I was not anticipating this objection to the scoring. Unfortunately, I'm left having to say I'm almost certain there's a case that was just recently decided about a defendant giving testimony at the interview, but I don't think it's necessary in this case because 2 paragraphs later, when Mr. Stark was re-interviewed at the same time, he admitted to pointing the gun at her. So I don't think there was an actual interference with the administration of justice. I think that this was...
And that's why Mr. Carnes, I remember him saying the word attempt. There you go. So, all right.
And I believe, and if the court would like me to try and find it, because the defendant certainly doesn't have to confess or make a statement for the administration of justice to deter, I believe there's a case that was just recently ruled on that says that is not scorable under OV-19.
There, if I recall the case.
Mr. Harrison just helped me out with it.
All right, Mr. Harrison, go ahead.
It's the Dewar case, 511 Mich at 980. In contrast, a defendant's denial of culpability without more does not slow or prevent a criminal investigation or constitute an effort to do so.
Difference here, I think, is a denial versus a misdirection. And that is, so if a defendant lies to law enforcement that's different than a denial. If the lie or misstatement was an attempt to redirect law enforcement. For instance, Judge, I don't have any guns in my house, but then they look and there's a gun in the house. That's a little bit different. Or, Judge, it wasn't me, it was that guy. And then they go, that's a little bit different because they're trying to actually impact or redirect versus a general denial, is my understanding. So the court will deny the challenge for offense variable 19, although it's a good question. And I do appreciate counsel reviewing the guidelines.
Clarifying the denial, does that mean we're not scoring it?
Yeah.
Okay,
That's okay.
the phrasing and the way it was raised, I didn't understand.
I think my phrasing was perfect. Yeah. It was wonderfully stated.
I agree. I was just slow enough to not understand it.
That's okay. Mr. Carnes, any other corrections or amendments?
No, Your Honor. Thank you.
Mr. Chair, full allocution, and you may address both.
Thank you, Your Honor. That's what I was going to ask. I do believe we have a victim statement. Just want to make sure.
I do have a written statement.
Does she wish to make a verbal?
She wishes to make a verbal.
Ma'am, you may approach. Your goal is this. If you wish to bring somebody up with you for comfort, that's appropriate. No worries. All right. Your goal is that podium. Before you start to speak, I'm going to ask for you to please state for me your first and last name.
Sandra Valentine.
All right. And Sandra, would you please, I know it's probably common. Is it a common Sandra? That's a yes.
Yes,
Thank you. And Valentine, common spelling?
just like the holiday.
Just like the holiday and the saint who got us, makes us spend money on cards. All right. Thank you, ma'am. What is it you wish to say? You can have someone else read your statement if it helps you.
Okay, she brings it.
She may hold it and I can see it from there.
Do you want me to read it? She wants me to read it for her.
Okay, ma'am. And so let's tell me what your name is.
I'm Tricia.
Tricia?
Tricia, I am her sister.
All right. And your last name, ma'am?
Fast and easy.
Oh, you're going to have to spell that one for me.
B as in boy, A-S-A, N as in Nancy, E-S-E.
All right. Thank you, ma'am. You may.
Okay, so I'm,
Pursuant to the law, and I've already established the fines and costs. The court will place the defendant upon a period of probation for 18 months. The court adopts the terms and conditions for probation that are listed on CFJ 145, pages 2 and 3. Court finds, again, that those terms and conditions are well suited for this particular kind of case involving controlled substances. As to any period of confinement, the court is going to sentence the day for both counts to 68 days with 68 days of credit. Now, as to the other file, let's go ahead and comment a little bit further. I have a conflict here. I'm being told, and I don't think Mr. Chairman is saying this, and I'm not blaming him. He's doing a great job today advocating on behalf of his client. I'll note here, he didn't take much accountability. No, he doesn't have to. He was blaming a lot of it on her. As far as every class I've ever taken, that's 100% what I expect from a domestic abuse. Then lied to law enforcement, but thankfully they found the gun, and the gun was a 9mm with a round in the chamber. You pointed the gun at her with a round in the chamber. That means you had to put it into the chamber. I would really have liked to know, when did you ratchet it and put it into the chamber? Oh, and it was a hollow point round. This concept of smiling and pointing the finger at her only offends this court. Not personally, but professionally. You pointed with hollow points and a round in the chamber. Good Lord. I find that the sentencing guidelines do not adequately account for the offense. I take a look also at the benefit that you've received from the reduction of the charge. I don't blame anybody for that at all. However, the court finds that the guidelines, again, are inadequate. But thankfully, they are only suggestion. They are a tool for the court. I find that the conduct was substantially compelling to go above the guidelines, and the court sentences the defendant to 365 days in the county jail, and the court awards the defendant 37 days of credit. The court places the defendant upon a period of probation for 36 months. I adopt all the terms and conditions that are listed on CFJ 145, pages 2 and 3. I find that they are well suited for rehabilitative purposes, considering the nature of the offenses and all the factors that I've discussed today on the record. Mr. Stapleton, have I missed anything?
Your Honor, I neglected to put in no contact condition.
Oh, if the court will direct the probation or office to, when it prepares the orders for probation, to have no contact. Also, while I failed to mention it, the fact that the defendant kept violating his bond by violating this court's order by having contact with a domestic violence victim definitely supports the sentence given by the court. Thank you. Anything further, Mr. Carnes?
No, you're all right, thank you.
Mr. Chair.
Your Honor, just confirming the sentences of the
Oh, yes. You run concurrent with one another. Thank you.